call the meeting to order. First of all, thank you for everyone for attending. It's very unusual to have such a large audience at the Zoning Appeals Board meeting, but you're certainly welcome. I'm glad you're all here. The first thing we're going to do is I've called the meeting to order. We'll have a roll call and establish that we do have a quorum.
Laura Wigand, present.
Pete Bauman.
Bill Murphy, present.
Jim Holloway, present.
Can you all remember to speak into your mics, please?
All right, we do have a quorum, so the meeting will proceed. The second item on our agenda, as it's shown now, is our annual meeting where we elect chairman, vice chairman, and secretary. But if everyone's in consent with that, to save time for all the public in attendance and to get on with the business, I'd like to move that to the end of the meeting once this item before us has been resolved. Is that okay with everybody? We'll just skip over that now and come back to it later. Okay, very good. All righty then, moving ahead, if everyone please would stand and help me repeat the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. All right, next item of business is we need to adopt and approve the agenda. I'd like for someone to make a motion to approve the agenda as amended.
I make a motion, we approve the agenda as written.
Okay,
Second.
all in favor?
Aye.
Aye. All right, that's approved. Next item is a quick review and approval of the minutes from our last meeting. Has everyone had an opportunity to look at that?
Yes.
Yes.
Okay. The only comment I have, and Tracy, this would be in towards the bottom of the first page where it says there are no public comments to be heard. In that next paragraph, it says a motion was made by Jim Holloway and seconded by Laura Dolores Blackburn. I think that should just say Dolores Blackburn, okay? All right. It's a minor point, but I know you like to get those. That's right. Okay. All right, that's all I have in relation to the minutes from last meeting. I'd like to entertain a motion to approve the minutes as amended.
A motion to approve as amended.
Second.
Second, okay, all in favor?
Aye.
Aye. Okay, minutes are approved as amended. Okay, Ms. Nunes has already read to you the comments about the public hearing, but I think it's important to read those one more time. I want to be sure that everyone's aware of that and hears it from me. This is concerning general conduct by all participants at a public hearing, and this was adopted by the Cape Charles Town Council. And all persons addressing the Board of Zoning Appeals will stand behind the lectern, state their name and address, and affirm by oath that they are providing truthful testimony for the matter at hand. No person shall use inappropriate language or verbally attack any Board of Zoning Appeals member or any member of the public or of the town staff. Signs and placards are not allowed inside the meeting room. Any person whose behavior is disruptive and shall be asked by the chair to leave the meeting room. Persons may not question individual Board of Zoning Appeals members or staff members without the consent of the chair. Comments must be limited to the public hearing matter at hand. Public comments will adhere to the guidelines for citizen participation adopted by Town Council July 19th, 2021, and I understand we do have copies of that available. Okay. All right, and finally, there's a 3-minute time limit for each member of the public who wishes to speak regarding this. The applicant and or their representative shall have 15 minutes to make their presentation. And are you going to keep the time, Tracy, or is that?
I should introduce, we have a new staff member in our
Okay.
department, Robert James, or Bob James. He is our zoning compliance officer, so he is joining us for the first meeting.
Okay. Welcome, Bob.
Thank you, Bob. And he will actually be doing our timekeeping today, so he will,
Okay.
when he gives you the signal, Chairman, that will be the time.
Okay. All right, good. So is everyone aware now of that? If you have any questions, ask now. All right. If not, what I'd like to do is I'd like to swear in everyone at one time rather than take the time to do it individually. So Anyone who is proposing to speak this morning or offer testimony or evidence of any kind, please stand. Very good. All right. Do you swear or affirm that the evidence you shall give to the board in this action shall be the truth and nothing but the truth? Please respond by saying, "I do."
I do.
Okay. All right, then the record will show that we have sworn in all people who want to appear before the board this morning. We won't need to do that individually except to have them state their name and address. Okay, so I think that's the preliminary bookkeeping type stuff. Hold on just a minute. I've got so many papers this morning, it's going to take me a second. All right, we have no old business from the previous meeting, so I think we'll proceed to new business. And I'm sure most everyone's aware, but the business before us today involves an application from Harvey Elam appealing the decision from the zoning administrator dated January 24th, 2023, which affirmed that an alley does exist from Pine Street to Strawberry Street for the lots located between Washington Avenue and Jefferson Avenue, which led to the denial of the zoning clearance application at 214 Washington Avenue to locate a fence in the rear of the yard 1 inch from the rear property line as being in violation of Cape Charles zoning ordinance 4.2.g, which states that a fence or wall must be 2 feet from any sidewalk, alley, or public right-of-way. Said appeal application is authorized pursuant to Cape Charles zoning ordinance, section 2.6.2C and 2.6.4. This property is located in the residential R1 zoning district. Okay, so that's the matter before us. So I think to proceed, Tracy, do we have letters or comments that need to be read into the record from people that aren't here?
If I may, Mr. Chairman, I think we should lay out the presentation from staff and then from the appellant before we take public testimony from the public at large.
Oh, okay, all right, we can go that way first. All right, do you wish to go first, or should
Yes,
we?
please. Just so everyone can understand the issue at hand as to how the decision was made and what is being appealed.
Okay,
As you stated, we received an application from Harvey Elam for 214 Washington Avenue, seeking to locate a fence in the backyard of their property. In that application, which was actually filed to go before the Historic District Review Board, we at that point did a review of the application to see if it was consistent with our zoning ordinance and did it comply with everything. At that point, we notified them that their site plan, which indicated within their application and on the site plan that they are looking to locate this fence within 2 inches of their property line, and that was not in compliance with the zoning ordinance. They came back and indicated they did not believe there was an alley affecting their property, and so they were holding firm in their application to the town. We went back further and we said we provided them some information that showed that the office had received in the prior last 12 to 24 months, information proving that there was an alley between Washington and Jefferson from Pine to Strawberry, that we felt that there was an alley and we needed to now adhere to that and enforce the zoning ordinance requirements, which does require a setback of 2 feet away from an alley, street, or sidewalk. At that point, again, we asked Mr. Elam if he could provide some proof, such as a title work that had been done on his property that would show that that alley had been negated based upon the information we already had in our office relative to the alley being in existence. We continued to have a conversation with him, and at some point I then offered, in the late fall, I said, okay, let me see if I can do some cursory title work. It's really not my field of expertise, but I have just enough that I think I can find a few things. And I said, I think I've got confirmation that there's an alley here, but let me see if I can do some title work to see if that has been negated in any way, shape, or form. And so with that said, I did do a little examination. I looked at the end pieces of the 2 alley at Pine and Strawberry, and I also touched upon a couple of the lots making up the interior sections. I didn't do every lot. I'm not a title examiner. I've indicated I do not practice as one either. I was just trying to see what I could locate within the deeds that are available publicly and stuff within our office that we had had some conversation about over the last year relative to this area of town and whether there's an alley or not. So, within my packet, there's many attachments. I'm not gonna go through each one. They're entered into the record, by the existence of both my letter to the ELOMs and then the staff report that was prepared for today's hearing. But I did wanna start, with the sheer fact, that the map I did here within the staff report kind of outlined and tried to pinpoint exactly which areas of that block the various attachments were relative to. I did that as well in my letter to the ELOMs, but I think I did a better diagram in the staff report, just to make you aware of that. I wholly acknowledge that the alley has never been opened all the way through to Strawberry Street. That is not a question, but nor do I think an alley needs to exist from one end to the other to traverse all the way through to be considered an alley under the town's zoning ordinance. I just wanted to state that. So we provided evidence from 1923, which then in turn transferred into a deed that was sold in 1925 to Albert Dutton that actually concerned the opening of the alley for the first time on Pine Street coming in. From there, we have been provided from one of the property owners a copy of their title insurance policy, which also acknowledged and supported that that alley existed on those lots in the block that is identified as A in my map in the staff report. Again, as I said, we've never questioned anywhere that the alley has or has not been opened to Strawberry Street. We recognize it has not been opened, and we are not questioning that, and we do not see that the current property owners wish to have it opened onto Strawberry Street either. As we kept on moving forward on our documentation, again, I did not do the title research for the other side of what I consider the other half of the alley, as you, on Pine Street, on the corner of Jefferson. Rather, our office had some communication information on this that they shared with me, that this had been applied for a building permit some years before, and Mr. Brady, our building official, remembered that and pulled the documentation from that time frame in which that property owner was required to move back where they wanted to put their addition to stay out of the alley. And then there was correspondence from then town planner Tom Bonadeo noting the alley as the reason for why that addition had to be moved.
And excuse me one second, and that was in when was that? 77, I think, or 79? I just want to be clear when that was.
Actually, no, it was 2018.
2018,
that
okay.
the correspondence was from the town planner at that time, Tom Bonadeo.
Oh, okay.
So I'm putting that on record just because that's a government official who acknowledged that the alley was there and made certain rulings out of that office at that time relative to it.
Thank you.
Then the next area that I focused on was in the middle of the block. And so again, I had some deed reference that we included from that, from the William Scott Estate to Leonard H. Richardson. It also included some language regarding the alley, so we provided that. I then did look at more recent communication we received from some of the residents in that area. We've been supplied information from the Wagners, who own a lot over there. In their paperwork, they show the alley reference in their deeds. I did include their survey that was provided to our office. What was interesting is the survey noted it. It did not actually change when the survey updated their information for the Wagners from when the survey originally was done. All that was changed was the date reference. I just wanted to make everyone aware of that. As we continue forward, we had also been provided information from and sorry if I pronounced the name wrong, the Polizos, who also provided us deed information regarding the alley reference. I will say that in their documentation, their deed, while they referenced the alley, they didn't contain a component of what we've seen in prior deed information about the lots 85 through 88 down by Strawberry, determining the control of whether the Strawberry Street entrance would ever be opened or not. So their deed did not include that particular reference, but they included everything else relative to the alley. And then further, I located a sale of a substantial number of lots that were done in 2004 between Henrietta Morris and the Manual Development Corporation, containing, which within that sale is one of the Elam lot that's in question here today. I did state that this deed did not contain a specific reference to the alley. However, as we saw in many of these deeds, it contained a catch-all language, that this conveyance is made expressly subject to all of the easements, conditions, covenants, restrictions, and reservations contained in the duly recorded deeds and plats and other instruments constituting constructive notice in the chain of title to the property hereby conveyed. And that's actually a note that you see not only in the deeds, but also when surveys are done. Many of the surveyors are not doing the full chain of title work when they are constructing and providing the survey plats, but they are giving a disclaimer that this is being done in the absence of really knowing if all the easements are truly reflective on the plats and surveys that are being provided. Again, because we had not had much of the Washington Avenue side of this block developed, I felt it was interesting to look when the first house went in on that side in the middle of the block, to see what had been provided to the town at that point in time. And actually, when we pulled that file from the building permit records, we actually had a survey contained in that application which had extensive references to an alley within their deed descriptions on that survey plat. And so that was provided as well. So that is the information which I based my decision to deny the application from the Elams from a zoning clearance perspective, and it was not advanced to the Historic District Review Board for their review of fences, as at that time was required for the Historic District Review Board to take up fences. I note that for you because that law has changed by town council vote when they adopted new guidelines in December. Fences can be now administratively approved, but they still would need to comply with the zoning ordinance, so I still hold by my decision that I would have to adhere to the setback requirements with the acknowledgement of the alley being there. So in my staff report, I conclude with just making you aware of your powers and duties of the Board of Zoning Appeals as contained in section 15.2-2309, specifically dealing the decision on such appeal of a administrative appeal, which is what this is, shall be based on the board's judgment of whether the administrative officer was correct. The determination of the administrative officer shall be presumed to be correct. And it walks you through that process for you to follow. I also have provided you references under the state code, both to an appeal to the board in part, which is section 15.2-2311. And then since this is really where we are in the heart of this matter, it deals with section 55.1, 301, and 303, which is dealing with real property and how the state governs this, and it's the form and effect of deeds, easements, how construed, and then easements, appurtenances included in deed of land. So we included both of those sections for your information. I've also provided you the information in our Cape Charles zoning ordinance relative to fences and walls. And again, from my position, I still stand by the decision I have rendered, and I am seeking the board's support in upholding that decision today. So I will stop at this point. I will make you aware that the appellant is represented by counsel, Ms. Patrice Drake, and she is here today. And both the appellants, the Elams may speak, as well as Ms. Drake. So I turn the matter back to you, Mr. Chairman.
Are Mr. and Mrs. Elam present?
Yes, they are.
Okay, morning. I didn't recognize you. I wanted to be sure. Thank you. Okay, I think that what would be best right now, rather than to question Ms. Nunez's testimony or debate that, we probably should hear the other side first, and then all public comments, and then we'll take up a general discussion. Everyone good with that? All right.
Yeah.
Okay, you may proceed, ma'am.
Would you mind if I...
Oh, no,
Introduce myself.
you'll be all right there, sure.
Hi, I'm Patrizia Drake with the law firm of Bischoff Martingale, and I'm here representing Mr. Elam in his appeal. And I'll just go back to my desk to
That's
speak.
quite all right,
if you
thank
don't
you.
mind. All right, so Ms. Nunez was framing the issue that's before you and the points for discussion. She was framing it as the discussion needs to focus on some evidence that we have to present that the alley was vacated. But I think that's a little bit of a misstatement because our position is that the alley was never actually legally created, and therefore you don't need to vacate that which was not created. And so I put to you that we have put forward some evidence that clearly shows that the root plat that is referenced in all of these chains of title that we were talking about and that you've probably reviewed is always going back to book 41, page 483 through 484, 485. And I have included and put before you the plat from page 481, book 41, which in fact is the plat of the area and all the different blocks. And you can see the block in question on there, and there is no alley created or referenced or shown.
It's the plat of the town originally when it was.
Okay, that's why, this is the original plat of.
Right, that's the
Prop-
one
okay.
that is,
And this
that
is the
all of the
block.
deeds are saying that they are referencing back to this plat. The reason why it's not shown is very likely because if you look at the exact language of the purported easement in the deeds, I'm going to read it from the attachment to, from Ms. Nunez's packet, because it's easiest to read. Subject to an opening of an alley, and then it goes into detail where the opening of the alley would happen. And then it states, but the opening of said alley is conditioned upon the consent of certain lot owners. So the opening is conditioned on consent of certain lot owners, not just the easement being valid as against those lot owners, but rather the entire interest is not created unless there is a recorded interest of those lot owners, and the record does not show that any such interest, any such consent was ever given. This option was never executed, and in fact, I actually put before you also evidence on the record to the contrary. There is what I call them consenting lots, those at the end of the Strawberry Street. So just for ease of use, the consenting lots. There are multiple consenting lots and property owners, and one of whom had signed an affidavit that's before you, who had actually stated clearly that they reject the alley and they will not grant their consent. And it is our position that now, if ever the option could have been exercised, then it was exercised now, and one of the consenting lots has now revoked any such consent and is going to be willing to record an instrument that will state the same in court, saying that this consent is not given and will not be given for the opening of the alley.
Okay. And excuse me, I don't want to take your time, and please note that my interruption. When you say consent, are you talking about the 4 lots on the end that
Yes.
it states their consent would be required to open the alley on the Strawberry side, or Strawberry Street end?
To create the alley, because if you look at the language of the conveyance, it says that the conveyance is subject to the opening, and the opening is conditioned on consent.
Okay.
It's very clear. It can't be
Yes,
clearer.
I understand.
It's subject to the opening, and so it's my position that the interest was never created. This alley was never properly created, and it was in fact not shown on the plat that's specifically being referred to as the root of the title of the subdivision, right?
I'm sorry,
That's
Ms.
all-
Drake. They're having a hard time
Yeah, I was
hearing you
gonna inter-
online. If you don't mind speaking into the microphone.
Yeah,
we'd
and
appreciate
I
it.
want to be sure that this last 2 or 3 minutes doesn't reflect on her time limit. Okay, just, I don't want to impinge on their time. Okay, but I was trying to tell you that too, that I didn't want to keep interrupting you. I'm sorry, go ahead.
So I would say that there's actually evidence throughout the history. There's another plat actually before you, which is from 1921. It has a stamp of the town on it in a sort of a round circle. And it shows a similar layout of these blocks, and it's showing this particular block in question, and it is not showing an alley, although there are other blocks on that particular plat from 1921 that are showing alleys created within the blocks and going down in the middle between the properties, and our block in question actually shows structures being built right up to the property line. You can see that right up to the property line. So in 1921, obviously there was no alley created, none was platted, none was shown, and your town ordinance says that alleys can only be created by being accepted by the town, and they are. The acceptance, they have to be accepted by the town, and the town accepts platted and dedicated public alleyways. However, that has never really happened. So I don't believe that a letter from an administrator, another representative, that may have misinterpreted a conditional language within a deed as potentially pointing to an existence of an alley really creates or accepts the alley. There's no platted alley on that block anywhere. So there's, in fact, on the record that was presented to you in attachment 5 to the report. This one is lots 102 and 103B, McAllen. If you look at the drawing, well, first of all of the drawings that were presented, all of the surveys that were presented really always say that they were not done with the benefit of a title search. The only title search reference that's included in the record is really just making a general usual exception to this potential alley, because if it were created at some point and there was a recording was not noted as being in existence. And so do you have attachment 5? Are we looking at the same thing?
I'm trying to find attachment 5 now. There's so
And
much.
I believe she's referencing attachment
new
5 that
stuff
was
here.
attached to the town administrator's decision. It looked like this.
Right.
Okay, I don't seem to have that in front of me.
It's in your packet. Trust me, it is there.
Okay, yes, I
Oh,
see.
there
I
you
see
go.
it. Now I recognize
All right,
it.
attachment
I'm sorry,
5,
Lynn.
when you look at the very tippy top where there is an alley, sort of dashed lines at the top, it says possible 16-foot alley. It says possible alley. Right? So obviously, there is some acknowledgement that there is a possibility of an alley. However, none was ever platted, and when you look at the root of that title, the book 41, pages 483, 484, 485, the plat that you see from that, it does not show a created alley. It only speaks of the potential of an alley being created if there is a consent, if certain owners on that block agree to create this alley.
This particular plat that we're looking at here, and I apologize because there's so many maps and plat numbers and things, is this plat and this lot located in the section of the block where there is no alley now? Because they're partially through that block, there is an existing alley. Is this lot in that area, or is this in the area of the block the alley's never been developed through?
If you're talking about the 102, 102, 103.
103B, yeah.
So I just want to make sure that I make it clear that our position is that an alley was never created because it needed to be created by consent. But if you're asking about the 102, 103, that is actually closer to Pine Street. 1, 2, 3, 4, it's the 5th and 6th lot. from going from Pine Street. Is it on the Washington side? Yes. So, our position is that that all through the reason why this supposed alleged alley was ignored by the town, and some certain permits were given already, and that creates a certain inconsistency. Some permits were given, some people already built fences, and this is not just recently, but going back years and years, 30 years back, there were 30-year-old fences going all the way to the property line. If you look at the pictures going in GIS backwards in time, you really notice that there are just trees growing. There are boats parked, and there are sheds, and there are fences, and so it's definitely not created, and it's definitely not accepted by the town. I'll say that your own ordinance makes it clear that it would have to be platted, it would have to be accepted and adopted, and it was not. There is nothing on the record showing that. However, also, the plats that I put before you, they show that right all the way back to 1921, the property owners, through the whole supposed easement, were not treating it as an easement. They were building things. There are structures shown on the 1921 map, right there all the way to the property line. Because this option of consent was not exercised, and there is nothing on the record, and I posit that in order for Ms. Nunes to meet her burden of proof, her initial finding of correct finding, and deserve the presumption of correctness, is if she was to show you a recorded consent that triggers the creation of this alley, which there is no record of, but on the contrary, we are actually showing you the opposite. We're showing you a consenting lot not consenting. And we're willing to make a recording and show that this is not going to be created as an alley by lack of consent, and actually the opposite, rejection by the consenting lot. And if there is any time left, I would be happy to cede my time to Mr. Eason.
Okay. 2 minutes, okay.
Take anything I can get.
Unless you have some questions for me.
I do, but we'll hold them.
Okay.
We'll hold until, we're pretty much through everybody's input, and then, we'll have some questions, I'm sure.
Don't start yet. All right, first of all, it's an impossibility for an attorney to speak in 5 minutes or less, but I'll try to be brief.
We'll grant you some leeway.
I usually like more time to get prepared for these. I like the exchange that I have with Katie. I didn't have that this time, unfortunately, because I just was involved since Thursday. But I do concur that we start off at the wrong foot.
Can you just state your name and who you're representing?
My name is Carl Eason. I'm with Walcott Rivers Gates. I represent Beth and Jeff Howard. They own Lot 96. And their position in here is that they came to the town in 2017, and they went through the proper procedures, and they got the right to have a fence and a shed in their backyard. If you uphold the current determination of the administrator, what happens to that prior approval? And quite candidly, if you look at this right-of-way that's going through there, many other improvements in it. So we've got inconsistent treatment throughout the years. So let's start, first of all, with what caused this whole problem. The problem caused, once again, by attorneys in the drafting of that deed language. And in the deed language, it says, subject to the opening of an alley 16 feet wide from Strawberry to Pine. I heard, well, only portion of it's open, and that's all. That's not what these deeds say. It says open from Strawberry to Pine. You can't have a zoning administrator's decision that says one end of the street is fine and the other street is not fine. That deed is not a public deed. It's a private conveyance of a property interest. But what's more important, and you heard Patrice emphasize, is it says it's conditioned upon the consent of the parties. It's termed an alley. So first of all, let's look at Section 2 of the General Conditions of the City Ordinance. And an alley is defined. An alley means a minor way used primarily for vehicular access to the rear or side of properties otherwise abutting a street. For an alley to be recognized as such by the town, it must have been previously officially adopted by the town. So we start off with Ms. Nunez saying the applicant hasn't disproved the existence of the street or the alley. And I think we got the horse exactly backwards, because an alley says it must be officially adopted. When we look at the 1920 plat that the chairman,
That is the end
Oh, I'm sorry.
of Ewan, the streets talk. Mr. Easton has signed up again for 3 minutes of his own.
Oh, okay, all right. Would you wish to start that 3 minutes?
Certainly.
On your own time now? Okay, let's proceed then, excuse me.
all right, so what we look at there is it says it's conditioned upon the consent of 88, I can't even read it, the four consenting lots, 85 through 88. If you look at that plat that was handed up to you, that's the bottom left-hand quadrant. And the lots 85 through 88 are on the Strawberry side. That's the affidavit that says not only do I not consent, but I also tell you that I have no knowledge that my predecessors have consented. It's also ironic that that's Mr. Coffey's lot. He came before you and he got an approval to have encroachments in this same alleyway, and you cannot have it both ways. You don't build in the alley and encroach upon it and then say it's okay to open the other side. It says the entirety. If we read it, it says from Pine to Strawberry, no exceptions in between. So now let's look at our zoning ordinance under 62-3, and it starts off findings of facts. There are throughout the town several alleyways that have been used by the town for providing services. I don't see anything in the zoning administrator's report that says this has particularly been needed for the services. Those alleyways are platted and dedicated as public on certain plats recorded in the land records, and the town has never formally accepted those. So that was a way of saying, hey, if you've already got those alleys that are in existence and they're already platted, then by enactment of this ordinance, they'll automatically become something within the town's purview. This was never platted. It's not an alley within Section 2 of the General Terms and Conditions, in my humble opinion. But we don't need to go there because we've got the issue of consents, and we've already covered that briefly. The Coffey building on it, the Coffey affidavit, Katie cites us to say, look, as part of my consideration, I looked at surveys, and some of them said the possibility. A survey is going to give you your lot dimensions at 40 by 100, and they're going to insure that fee. And if there's anything that might affect that fee, they're going to typically put it in there. They're not lawyers. They don't interpret the deeds. And that's why you see possibility of an alley, because there was nothing that evidenced for that surveyor that there was or wasn't one there, but he saw that deed. So protect your liability, disclose it. The next thing is we look at that title insurance policy. Title insurance policies is if we think we have an encroachment upon our lot, we call up Fidelity and say, I'm making a claim on my policy. So to protect themselves against the very kind of claim that we're sitting here and arguing today, is there an alley or is there not? Lawyers Title in that instance said, we take exception. Don't come back to us and talk to us if there's later a claim for the opening of this alley, because that may affect your underlying fee. Those are not dispositive of land ownership. So the main thing that you have to worry about is I think that the deed itself says there can't be a partial opening. It says it shall be from one side to the other. Number two, you've got inconsistent treatment from the zoning administrator. So if we're correct today, then we sure have been wrong in the past. And I think that Ms. Nunez has been very candid with you in telling you that there has not been a uniform enforcement of this across the path. But think about the people that came through here, the Coffeys, the Howards, the people that have already gone through the gamut. They've gotten an approval letter, and the approval letter says you can have the restrictions in there, and now we're telling them that this decision will negatively impact them.
Thank you, sir. That's the expression of your time. I would say, as a final comment, Ms. Nunez and the town have officially acknowledged to everyone that mistakes and errors have been made in the past. So
Sure.
Nobody's trying to deny that or say it hasn't happened. I think what the intent is to say, yes, we've made errors in the past, but we don't feel like we should make any more. I mean, that's just briefly to answer a couple of your comments, but your points are well taken, I think.
All right, I find myself without time, but one point that since if this does go anywhere, it goes to the circuit court, and you have to have a record. I have an argument based upon the rule against perpetuities, which is a purely legal argument. Yes. I can proffer it in a minute, or you can allow me time to proffer it to the record when we're through. but I don't want to waive it if we end up going to circuit court.
Okay, I don't have any objection to that, but I do need to preface before you do that with something. First of all, the rule of perpetuities is something, I'm not a lawyer, but the rule of perpetuities is something that's very debatable, and I think very few people have ever nailed it down firmly what it applies to and what it doesn't. It's a very debatable topic, okay, so we all know that. The other thing is, this board is here not to render a legal decision, because as you correctly stated, that's something that the court would do if it comes to that. Our point in being here today is to hear the evidence and the testimony that's brought before the board, and merely to make the decision whether or not we as a board feel the zoning administrator made a proper call based on what we have before us. We're not here to debate or decide if the rule of perpetuities applies or any other fine legal point. That is something that, if it has to go to that, will be decided by court, okay? As long as everyone understands that's why we're here, because I'm not qualified nor prepared to debate the rule of perpetuities with either one of you, but now, sir, having said that, go ahead.
All right, and having heard you say that, it is also your duty to hear anything that says, hey, this was wrong and here's why it's wrong.
Absolutely.
And so that's why I'm trying to introduce it.
Absolutely, go right ahead.
So I'm going to focus you briefly to 55.1124, and that's the infamous rule against perpetuities. It is not well understood. It is disfavored in many jurisdictions. It lives and survives in Virginia, as many things that hang on for a long time. But basically, it says whenever you create an interest in a lot, it must be certain to vest not later than 21 years from what's called a life and being. So let's assume for a second these deeds were given out in 1920, and it says there's a possibility of an easement, a right-of-way, an ingress and egress that will be given. The fact that it shows up in that deed, that starts the clock running. Now, how do we tell the clock? It says from a life and being, a measured life is what it's called in the law. So that means if I convey this lot to you, you are the measured life. So it's going to be a interest that is in existence during your life and then for 21 years beyond your life. The key to the operation of a rule against perpetuities is that it must vest, if at all, within that period. So if we look at this scenario, is there hypothetically a chance that that consent wouldn't be given during your life? And maybe that consent wouldn't be forthcoming for 21 years thereafter? If it's not a certainty and there's a possibility that it won't vest, then the conveyance is invalid. So that's the Reader's Digest version of what you're dealing with on that. And I think this does exactly that, and I think you can probably find many scholars to disagree and debate, but I wanted that to be left in the record. I don't think we can have a partial opening, and one of the things that's missing from this more than anything else is, Virginia is what's called a race notice state. And notice means I go to buy property and I look at the deed and I see that Pete has a deed of trust on the property. I know that I'm subject to that. When you go and you search these properties and it says the possibility of an alley, you don't know whether that's occurred or not. But the burden's not upon Mr. Elon, the applicant, with negative implications to my client to make that burden. The burden is to show me where were the consents given originally that consent to open this alley, and number two, does this alley appropriately exist under the ordinances of Cape Charles? Thank you for the extension of time.
Thank you, sir. Okay, so we've now reached a point where we've heard the town's presentation, we've heard the attorney's presentation. I think now we start with public comments. And we want to start with the letters, if there are any letters that need to be read in. Oh, yeah, I'm sorry, thank you. Before we go any further, would the applicant care to make a statement himself or herself? You're good? Okay, fine. I just would be sure we did offer you that time if you'd like to come forward. Okay, all right, Tracy, go ahead.
Okay. The first one is from Anthony Story and Ann Stratton. Ms. Nunez, we are writing concerning the appeal pending by Harvey Elam to further restrict alley access to the alley existing in the 200 block of Jefferson Avenue, Washington Avenue by the fence addition. We agree with the documentation provided by the Planning Commissioner, Ms. Nunez, that there has always been a legal easement in the above area to provide access to the rear houses. Until the construction of the newer housing facing Washington Avenue, alley access was never an issue, and we would strongly support returning the alley to its prior state of providing total access from Pine Street to Strawberry Street. As owners of lots 86, 67, 90, 91, we are strongly in favor of denying the homeowner's request. Also, other issues that have been created denying complete alley access should be reassessed and rectified. Sincerely, Anthony Story and Stratton, 223 Jefferson Avenue. Jeremy and Sarah Drumheller, 209 Jefferson Avenue. Ms. Nunez, we are in receipt of the appeal to the zoning board by Mr. Elam at 214 Washington Avenue. We want to thank you for taking the time to prepare a thorough review of the deed history and your response. As you know from our previous conversations, we verified that alley access was recognized by the town before we purchased our home over 10 years ago at 209 Jefferson Avenue. As is documented in attachment 3 of your response to Mr. Elam's application, the alley is extremely important to us and to most of our neighbors. We will attend the public hearing on Tuesday, April 11th to support the town's decision to deny Mr. Elam's application. Thank you, Jeremy and Sarah Drumheller, 209 Jefferson Avenue. To the Cape Charles Board of Zoning Appeals. I am in full support of the town's ruling denying the application for approval to install a rear fence at 214 Washington Avenue due to the intended location of said fence. My reasoning is as follows. Number 1, the alley running from the east side of Pine Street to the west side of Strawberry Street has clearly and legally established over 140 years. A full title search and deed book review shows the existence of the alley dating back to the 19th century and describes its width, length, location and is included in numerous deed citations. Number 2, my property, like many others, was purchased as indicated by our deed and title research with the understanding that there is an alley providing access to the back of our property, and that was an important factor in our decision to purchase it. Unencumbered access to the alley is essential to the value of my property. Number 3, there is a reason why our auxiliary buildings are currently located where they are, because it is an alley and in compliance with town regulations as directed by the town. Number 4, approval of the fence location and construction at 216 Washington Avenue would have a negative impact on property access affecting lots both Washington and Jefferson Avenues. Number 5, the relative utility of the alley is apparent. Many of us park our boats in our backyards, and in some cases, the alley provides the only way to get to our boats, trailers, or golf carts in our backyards. Now that the town has decided to end boat trailer and equipment parking at curbside, access to the rear of the properties is all important. Number 6, gas deliveries are made using the alley, and contractors, tradesmen, and landscapers all use the alley. The maintenance of the alley has been undertaken over the last 3 years by a few of us, and gravel has been spread at our own expense in order to facilitate these services. Sincerely, Justice Cavonas. I hope I got his name right. Katie, I have sent your email to my attorney as this was not disclosed to us through our title search at settlement, and our surveyor made it very clear that there is no alley when we met on site. Being we were not notified by certified mail of the meeting at least 30 days prior to the scheduled date, as all owners, we are respectfully requesting an extension of the meeting so the proper due diligence can be conducted with the short notice received, and living out of town, John and I are unable to attend the meeting scheduled for 4/11. Please confirm this email has been received and acknowledged. These are new homeowners.
Okay, and I'm sorry.
Karen Parr and John Sarver.
Did they said they had talked to their attorney. Did they have counsel present today, or are they represented by
I don't
anyone?
believe so, no.
Okay, okay.
No. They've been speaking with, we used a GIS system that Northampton County provides, right? Well, I'll move along. Okay, this one's from Patricia Cobb. We reside at 217 Jefferson Avenue, almost directly behind Mr. Elam. For the past 28 years, we have helped maintain this alley to provide access to the back of our houses, sheds, etc. From the research our neighbors and Katie Nunez has provided, the town, there should be no question this alley is open. Why another 2 individuals were granted a go-ahead to block the alley is a mystery, and I hope this can be rectified at some point. We feel this battle has been fought so many times. Thank you for your time. David and Patricia Cobb. If given the opportunity to express our opinion at the Cape Charles zoning appeal hearing, we respectfully submit the following statement. This dispute with the alley has caused unnecessary animosity in our neighborhood. After reading various deeds for the homes on our block, it seems apparent that an alley cannot exist unless consent is given by the owners of lots 85, 86, 87, and 88. The owners of lots 85 and 88 have no intention of opening the alley. Acknowledging that we are not legal authorities, we suggest that a neutral, qualified party research and interpret all the deeds from Pine to Strawberry in an effort to resolve this issue. We feel very strongly that every resident should be treated equally. If one neighbor is given a permit for a setback without an alley, other neighbors should be allowed the same. If the town has issued permits in error, it is only fair for the town to correct the error at the town's expense. If asked our opinion, we do not wish to see an alley running through our block. The reason being, several neighbors have chosen to intrude into the alley, positioning unsightly items that we are forced to view from our backyard. We did not purchase a home in an historic neighborhood for a view of boats, trucks, trailers, and piles of debris. Respectfully, Kevin and Judy Reck. To the Cape Charles Board of Zoning Appeals. Our names are Joe and Lori Wagner. We have been full-time residents of Cape Charles for 13 years at 211 Jefferson Avenue. We would like to make clear that we are in full support of the town's ruling denying the application for approval to install a rear yard fence at 214 Washington Avenue due to the intended location of said fence. By all means, Mr. and Mrs. Elam should be able to install a fence pursuant to Cape Charles Zoning Ordinance Section 4.2G and respecting the indicated setbacks. It is our understanding that this letter will be read at the hearing scheduled for April 11th, 2023 at 10 a.m. Our reasoning is as follows. Number 1, the alley running from the east side of Pine Street to the west side of Strawberry Street has been clearly and legally established for over 140 years. A full title search and deed book review shows the existence of the alley dating back to the 19th century and describes its width, length, and location, and is including in numerous deed citations. Number 2, our property, like many others, was purchased as indicated by our deed and title search, with the understanding that there is an existing alley providing access to the back of our property, and that was an important factor in our decision to purchase it. Unencumbered access to the alley is essential to the value of our property. Number 3, there is a reason why our auxiliary buildings are currently located where they are, because it is in an alley and is in compliance with the town regulations as directed by the town. Number 4, we have voiced our concerns to the town early on that approval of fence location and construction at 216 Washington Avenue would have a negative impact on property access affecting lots on both Washington and Jefferson Avenues. Number 5, the relative utility of the alley is apparent. Many of us park our boats in our backyards, and in some cases, the alley provides the only way to get our boats, trailers, or golf carts into our backyards. Now that the town has decided to end boat, trailer, and equipment parking at curbside access to the rear of the properties, it is important. Number 6, gas deliveries are made using the alley, and contractors, tradesmen, and landscapers all use the alley. The maintenance of the alley has been undertaken over the last 3 years by a few of us, and gravel has been spread at our own expense in order to facilitate these services. Spin Custis and Brian Ehrman and Crystal Stevens, property owners. That is all I have for the written comments. I have one more, but their attorney spoke for them, so
Okay.
I will not be
just for the
reading
record,
that.
One more time, who is that?
the last one?
Yeah, I just.
That
just
one
have
was from Joe and Lori Wagner, 211 Jefferson Avenue.
211 Jefferson, okay. Thank you. All right, so we've heard the two sides, and we've heard the written documentation, so, yes.
We do have a lot of people who signed up to speak.
Oh, yeah, that's the next thing we're going to get to is the speakers, and I guess that in the order they signed up, however you want to do it. And I would remind the speakers that there is a 3-minute time limit, so please be concise with your comments. We can't go much beyond that, if at all, because there's so many people and we've got a lot to talk about. So, Tracy, go ahead.
We have Lynn Polisos, 219 Jefferson.
And while she's coming to the stand, I would remind one more time to everyone that's speaking that you have been sworn in under oath, and that still stands.
My name is Lynn Polizos, and I live at 219 Jefferson Avenue. My house was built in 1926. The alley was existing at the time, and it had a garage on that property. It's on my plat. It shows the existence of a garage. We had access, and the town also, not only, it was just a muddy place or just a dirt alley with grass, but we also had a curb cut on that thing the town put in. And when we rebuilt the garage, we had to comply with the ordinances of the town to make sure that we did not encumber the alley in any way. So we did have to move our construction somewhat, which was fine. I understand that at the property next door to me that belongs to the kids, they're Kathy and, it used to be Marty Kidd, but he's gone. Their fence has been in that alley for years, from the previous owners, which were the Johnsons. So we all knew that they just did it, and actually had to move the fence when Mr. Emanuel brought the adjacent lots in the back, because their fence encroached on his property and he couldn't get full deed. So they did move the back, but we have always thought that at some point the town would say, no, you're in an alley, you have to move your chain link fence. Well, the people at the Howards, they come up there. Now the whole alley is closed. There's that much space between the two fences. So I understand that it has been that they did not, the approval for 216 Washington was a problem, and that they didn't look at, she was new, she didn't have time to do all the research work on it. But that alley is so important because I have no access to a public road of any face. Either I could go out my front door and drive my car, but there is no access to my back of my lot or to where my shed is and all of my things. So the alley, we understand, cannot be extinguished by the action of less than all of the landowners benefiting. So apparently we have to have, that everybody would have to, vote against closing the alley. Okay, that's it.
I'm sorry, but did you want to finish your sentence? I don't want to cut you off in mid-sentence.
No, I just understand that, everybody's going to have to get into this, so they can change it. My deed tells me that this is the deed from the Mr. Start, who we purchased from,
All right, thank you.
that goes on.
Thank you very much.
Thank you.
Tracy? Next.
Good to go? Good morning. My name is Jacqueline Heller. I live at 220 Washington Avenue. I want to thank the board. This is a thankless job, and you have quite a decision ahead of you. I know absolutely nothing about zoning, so I can't give you any information that's going to make that any better. I am an elementary literacy specialist, so what I do know is the power of words. And our words frame our thinking, and that thinking impacts the decisions we make and the actions we take. So I am here not to tell you for or against your decision, but when I received the letter informing me of this hearing, I was reading along and I got to the sentence that said, the decisions made today, you're being informed because this may impact the alley you share with your neighbors. And I'd like to contend that that language is incorrect. So when I look out my backyard, there is no alley. In case some of you have not traversed this block, there is a alley entrance on Pine. There are several houses that have been using it as an alley historically, and then somewhere along there, it goes away, and there is no entrance on Strawberry. So when Ms. Nunez opened, she was talking about Tom Bonadeo and mentioned like that's a government official who acknowledged there's an alley. So if we are quoting government officials as data and evidence, I want us to implore all of us, community members as well as the board, to be very careful of the language we're using today. So I would propose that this is a alleged alley, a potential alley. There was language about a possible alley. The only true fact is there is an alley entrance. Where that begins or ends, we aren't sure. I don't know the definition of the alley, how your board will decide. What I provided is a couple of pictures to help you. So if you aren't familiar, the lot we're questioning is 214 Washington. The pictures that you see were if you were to start at that lot and travel up towards Strawberry. So the very next lot has not one, but two fences that sit right at the property line. So there is clearly no allowance for an alley on the adjacent lot. The next lot does not have a fence on the Washington side of the property, but 225 Jefferson does have a fence. And again, that's the chain link fence Lynn was referencing that sits right at the property line. Next is my lot with a shed that complies, that this board approved without the word alley ever being mentioned, that sits 5 feet from the property line. So if there were to be an alley, that would be in the way. You can see behind us, there's trees on the next lot that fill in what would potentially be an alleyway. And then the block ends, this last picture is taken from standing on Strawberry and looking towards that possible potential alley, where there is no entrance for it, and again, another fence that sits right at the property line. Okay. So I'm quick, less than 3 minutes, but I implore you just to be very careful with the language we use, especially, this letter that I received, this is an official government letter that claims the alley that I share with my neighbors is incorrect. So any notes today, make sure we mention it's a possible alley.
Very good, thank you very much. Since we've gone a little over an hour now and there's so many people here, I think we're going to take a 5-minute recess in case anyone needs to take a break or walk outside or use their facilities or anything. So it's 11:10 basically, so we'll try to reconvene about 11:15 if anyone needs a quick break. I mean, if no one does, we'll continue, but okay. So we're kind of... Could we come back in order, please? It's now about 11:20. All right, Tracy, if you would, please call our next speaker.
First one up after halftime. Good morning.
Good morning.
My name is Debbie Schlicht, and I co-own the property at 610 Pine. Okay. 2 points I would like to make regarding this hearing. As an owner of the property at 610 Pine Street, where all the ingress and egress is happening, okay, this does abut the so-called alley. I would like to know how the town has officially adopted this as an alley. The town administrator has used the terms alley, easement, and private alley interchangeably to describe this, what I call a man-made alley, which has been very confusing to me. By the town's own definition of the term alley, which is zoning ordinance section 2.9, which has been referenced this morning, it states in so many words, right, for an alleyway to be recognized as such by the town, it must have previously been officially adopted by the town. And I think both attorneys address that. The town's definition of an easement states it is a grant of one or more of the property rights by the property owner to and/or for use by the public, a corporation, or another person or entity. Now, these are two very distinct definitions. So my question is, what is it? Okay, quite frankly. All homeowners whose properties abut the so-called alley should have access to public documentation that supports how the town officially has adopted this alleyway. The fact that the town has previously allowed other property owners to install fences up to their lot lines, which lie in the middle of the so-called alley, seems to indicate the town has clearly not officially adopted this as an alley per their definition in their zoning ordinance. These inconsistencies further iterate the town's lack of alleyway ordinance policies. And if policy does exist, this town should be able to point us, the homeowners, to the de facto documentation that lists all officially adopted alleys. That's point one. Secondly, I would ask this board to request a broader representation of documentation the town administrator provided you supporting her denial ruling. The administrator has offered you a few deeds, all referencing the same alley language dating back to 1925 or thereabout. Now, I have personally researched other Washington and Jefferson property deeds that do not reference the alley. So there is inconsistency here, even on recorded deeds. I believe the documentation before you only represents the cursory review, which the administrator admittedly did. Your ruling, consider this, that your ruling will not just affect Mr. Elam here today, okay? As there are 20 other properties abutting this strip of land. I know mistakes happen. Is that my time?
Yes, ma'am.
Whew. Can I
Finish
finish
your
the
sentence.
sentence?
Finish your sentence.
I know mistakes happen, as admitted by the administrator. After all, we're all human beings here, and that is why we have an appeal board such as yourselves. But I believe this board deserves receiving more complete information, not a cursory review, so it can make a more informed decision.
Thank you very much.
Okay, thank you.
Tracy?
Daniel Coffey, 615 Strawberry Street.
Okay, my name is Dan Coffey, and my wife and I live at 615 Strawberry Street, and we are the owners of lots 85 and 88, the non-consenting lots. So we have kind of a different perspective. We're from the Strawberry Street side, not the Pine Street side of the supposed alley. At this time, there's no alley that even appears to exist from Strawberry Street. There's no curb cut, nothing. And it was referenced before, the deed dated 1446 from William L. Scott and Eddie R. Dunton. It gives 4 lots the option to be consenting or non-consenting to an alley going straight through the entire block. We also have another interest in that first, I didn't even know there was a zoning board ruling in January. I wasn't aware of it until March when we received the registered letter. And in all innocence, we appeared before the Historic Review Board and requested permission to have a shed placed 2 feet from the property line, the normal setback, and that was approved by the zoning review board, and Katie Nunez has both verbally and in writing given her endorsement of that. So there's some confusion. From my perspective, our perspective is, Macy and I, we do hope that we will not have to then, we've already had the shed built, it's to be delivered, we paid for it, making preparations, and then to find out, I'm not sure that we'd have to do that, but if it came to that, we'd have to move this way into our property, which would then sit right on our patio and fire pit, not desirable. So all to say, we're from a different perspective. We're not involved in a lot of the activity up at the other end of the street, but we're totally unaware that this could even raise its head, the prospect of an alley coming through our property and heading straight through to Pine.
Okay. Just to be sure, I have a question for you. So the lots that you own, just for clarification, your residence is already on those lots?
Right, 85 and 88.
And you received clearance to place a shed as you?
We did, and that meeting was February the 21st. The Historic Review Board gave us permission
Okay, the Historic Review Board, but that hasn't received zoning administration?
It has.
It has?
Received
Okay.
zoning clearance, yes.
All right. And it's on order but not installed yet, correctly?
On order and built, but not installed.
And, okay, good. I just don't read anything into that. I just want to be sure I have the right.
Yes,
Yeah.
yes, it's soon to be installed.
Soon to be installed. Okay, thank you, sir.
Okay, thank you.
William Baggett? Pine Street.
My name is William Baggett. I live at 608 Pine Street, and 608 and 610 Pine Street are the two houses that are at the opening of the alley on Pine Street. The distance between our two buildings is just a little over 16 feet. So the egress in and out of the alley is disturbing at times. It was mentioned that there is boat storage going on down the alleyway, sometimes as many as 3 boats. And people will come in from, not on our street, but they'll bring their truck in and hook up their boat, which is evidently being stored down there. And then they'll pull their boat out and then pull it back in during the season. If we look at the enjoyment of our property and good quality of life, let's just say. I don't deny people that they have a boat or that they're fishermen. I mean, I think that's great. But not everybody stores 3 boats in their backyard, nor do they come in and out of the alley, several times a day. I would also add that when we did first move in to our house, as part, the town asked me to improve the curb space and put down hard scrabble entrance. So I paid for that. I paid for that improvement on that alley for the entrance. So I believe everybody should have the right to enjoy their lives. They can be fishermen. They can, live peacefully in the town together. And I just hope we can achieve that somehow without, any other difficulties, let's say. Thanks.
Thanks, sir. Thank you.
Jeff Howard, 216 Washington Avenue.
Morning. My name is Jeff Howard, live at 216 Washington Avenue. We have a unique situation because we moved here, we bought our property 2017, and we went through the zoning process, put in a fence and a shed. And at that time, it was with the blessing of the zoning department. Katie signed off on it, Ms. Nunez signed off on it, and we understand there were several neighbors that were upset that we did what we did. And at that time, we were told, no, there's no alley back there. And we even received a phone call from Ms. Nunez saying, if you want to be good neighbors, you can move it ahead, 8 feet so we can just keep everyone happy. We didn't really view that as a zoning decision, especially in light of the fact that we had a chain link fence that had been there for 40 years on the property line, on the property behind us. It wasn't creating an alley. It was just creating kind of an appeasement. So we didn't feel that we needed to do that since we had approval. But as I go forward, I spoke with Karen Parr, and I read in the materials that Ms. Nunez provided. There's an email exchange that's interesting between Karen Parr and Ms. Nunez, where Ms. Nunez makes the claim that the authority granted by 85, 86, 87, and 88 lots is merely to open an alley, an opening in their yard. Their consent was being viewed by her as, well, this is just a thing, so you don't have to have the bother of an alley in your yard. But it doesn't apply to the rest of the alley. And that's not the way it's worded. Well, the way it's worded, it says that their consent, the alley is conditioned upon their consent. I'll go back to my neighbor Jackie's, use of words is very important here. The alley is conditioned upon that consent, and that consent has not been granted. In some of the proof here that we're looking at, that was the attachments that Ms. Nunez put forward, Lot 98, it says that it was altered and that the condition was removed, and then it's glossed over. The condition is never really addressed by the zoning department. What does that condition mean? I'm imagining if it's been put in deeds for all these 4 lots, I'm imagining that there's some authority that's attached to that. How does another lot owner remove someone else's authority from their deed? I don't understand that. If lots 85 through 88 have authority, I don't feel that someone else should have and that's a legal question, and someone should look into that because a deed has been changed. There's another example, attachment number 8. Karen Parr, in her same email with Katie, was told that a survey map is not proof. Yet, example 8, Katie puts forth a survey map as proof.
Thank you, sir.
Thank you.
Stephen Lang, 600 Pine.
Good afternoon. It's almost noon anyway. I don't watch public speakers, so I'm just going to read from my
That's okay.
notes. The basis of the appeal, when distilled to its most basic point, is that once the town of Cape Charles has made a mistake, it is precluded from correcting it. The town, by its agent, has acknowledged the existence of the alley in the deed chain of title for the adjacent lots for more than 100 years. The town, by its agent, has acknowledged it is an error in approving the location of the fence and shed at 216 Washington. The alley cannot be extinguished by an action if less than all of the landowners benefiting from the deeded access agree. That the appellants were unaware of the existence of the alley and the incumbent rights of the adjacent landowners is a matter for them to address with their council or title company. And that's really all I got to say.
Okay. Is that all, sir? Thank you.
That is all I have signed up.
All you have,
I
Senator?
would like to say so.
Yes, sir. We're going to recognize Mr. Elam for up to the same amount of time we gave council and town as the appellant. Yes, sir. Go right ahead. And just take your time. Your time won't start until you begin to speak.
Good morning, everyone. Morning. I just have a few announcements or a few questions about me being denied. Over the past year, there were 5 other permits granted that has an impact on the alley. 204 Washington Avenue, it took a month to get approved for a shed that impacts the alley. 218 Washington Avenue, another month. 220 Washington Avenue, a month and a half. 615 Strawberry Street, about a month and a half. Katie Nunez worked on mine since August of 22, 8 months. And here I am today. And during the midst of all this, she was approving all these lots. To me, it felt like a kick in the stomach. Why are you approving all these lots and denying me? And when she gave me the denial letter, after 3 days after I had to contact the town manager, 3 days later, she gave me the denial letter with all this information like she's been working on. And I just don't understand it. I don't feel fair about it. And I'm a little frustrated, and that's all I have to say. Just very frustrated.
I understand that. Thank you very much for your comments.
Yes, thank you.
All right. I think given the amount of information we've received, the amount of testimony, I would like to go back, and I feel like this is entirely proper, to go back and give Ms. Nunez a 3 to 5 minutes. Oh, and give Ms. Nunez 3 to 5 minutes to sum up based on what she's heard. And also, counsel for Mr. Elam would be given the same opportunity. And so I think without any further objection from the board members, we'll go ahead and do that. So, Ms. Nunez, if you're ready, would you need a few minutes, or are you ready to?
Sure. I think the only thing I would like to make sure the board is aware of, the town didn't adopt zoning until July of 1994. So I wanted to make you aware of that. I can't remember the exact date in July. We have that in our office. So prior to that, any buildings that occurred, any structures, any sheds, fences, etc., even any alleys that may or may not be in this town, again, we did not have a zoning ordinance until July of 1994 for the town as a whole.
Any other, anything else? Okay. Ma'am, do you have any?
Thank you. I just wanted to stress that there was a lot of talk about the mistakes being made, and I would put to you that you actually got it right the first time, and you allowed a lot of these lots to build and have vested interest in the buildings and the structures that they had put on their property, and that are now in there, so I think you in fact did get it right the first time, and you should not reverse those decisions. The impact could be catastrophic on many of the lot owners. But also, we have put in front of you some evidence that directly refutes any creation of a platted alley, and rather points to, right from all the way to the beginning of the root of the title, points to non-existence or not creation, not triggering this option to accept this opening of an alley. So that is on the record. As previously noted, some of the evidence that was put forth by Ms. Nunez is not evidence of the creation of the alley, such as the title exception or some surveys that are essentially disclaiming and just sort of covering and saying this may not be accurate as to any encumbrances or possible alleys that may or may not exist. So I don't think that she has met her burden by doing the research that she has done. Now, we have given you the root of the title plat, and it's not platting that alley. your own ordinance would accept, officially accept alleys and recognize them. However, they have to be platted, and they have to somehow exist in the record. And there also has to be some sort of consent on the record, which you now have in front of you. A blocking of the alley, or essentially abandonment of the alley, and an exercise of this option that was reserved for certain lots only. You had an owner here, and you have his affidavit signed saying that he has not, and his predecessors entitled to the best of his knowledge, have not exercised this option to accept and open this alley. And the opening of the alley is subject to his approval among one of the consenting lots. This has not happened, and it has not been triggered. So I put to you that we have met our burden to overcome some of the circumstantial evidence, and also this language that makes it clear that the alley would have to run from the beginning to the end. You can't choose. You can't pick and choose by zoning. I'm going to only enforce an alley existence, even though there's express language in an instrument that's recorded. I will only enforce it against part of these lots. And you, I will tell you, you're fine, you're okay, this doesn't apply to you. But you, this is gonna be applied against you. So either the alley is created in its entirety, or it isn't. Now, the consenting lots and the town, by significant action, have abandoned this supposed alley, this alleged alley, this potential alley that may have existed. As my colleague here also pointed out, I had brought up in my appeal the very real possibility of the applicability of the rule against perpetuities, because this is exactly the type of dangling interest that is not supposed to remain in chains of title and make it impossible to figure out who is going to have some vested right or an option they can exercise 100 years later. And this would have involved an exercise of an option more than 120 years after this option was created. This would date back to 1891, I believe, would be at the death of Mr. Scott, would probably be the beginning of his measuring life, which would have to then vest within 21 years. Hasn't vested. We know that in 1921 there are buildings on a map inside that alleged easement, and so the alley was not open, evidently, and years later we do actually now on the record, pardon me, we do now have on the record a consenting lot not consenting.
Thank you, ma'am. Thank you.
Thank you.
Okay, well, first of all, because I may not get an opportunity to do this at the end, I'd like to thank everybody for coming today and being here, the Elams, both councils and members of the public, because these decisions sometimes are very easy to make, sometimes they're very difficult, sometimes they hinge on a fine point of law, sometimes it's common sense. But in every case, I think in order to do the job to the best of our ability, it's necessary for us to hear everyone's point of view, give equal time to that, and consider everyone's wishes. Now, how often do we accomplish that? Virtually never, because usually someone is happy and someone is not so happy. But our goal is simply to the best of our ability, provide our honest opinion based on what we're obligated to do as a Board of Zoning Appeals. We are only here to exist in matters of zoning variances or appeals. And in fact, some of the zoning clearances that were issued, if they didn't appear to violate any zoning regulations, we wouldn't even be involved. So we are by definition and name a Board of Appeals. So I would just like to thank you once again for coming, and I hope when we do wrap up here that everyone today, everyone's not going to get what they want, I don't think, but I would hope you would all leave here with a sense that you were treated fairly and given an ample opportunity to speak your mind. So and I say that now instead of at the end because I know everybody's gonna be up and out, and I just wanna be sure I said that as a board and as an individual. All right, going forward, we have received a lot of evidence, and I think probably everyone needs to consider that for a bit, but,
Mr. Chairman?
Yes.
You do need to formally close the hearing.
thank you very much, okay.
Public hearing.
Thank you, Katie. Okay, this closes the public hearing portion of our meeting today. So we'll move on to the discussing and adoption of a motion. All right, I'm just going to start out, and we'll probably have more discussion as we go, and there may be questions we have for some of you or council. Ms. Wygant, would you like to kind of start off if you have a summation or questions or something?
Sure. I just find this so ironic that the one county in the country that has the oldest records of anywhere in the country has such conflicting records. I mean, I know my deed was conflicting when we bought our house. It wasn't even the correct year that my house was built. But I do have a question for Ms. Drake, actually. This paper that was, the plot that was submitted here, showing what I believe you said was the block where that is in question, showing that there is no platted alley where it was platted elsewhere. It's showing, to my understanding, it's looking like it's Nectarine to Fig, a block of Nectarine to Fig, the Washington Jefferson block.
Just check that we're.
Where you said there was no platted alley here, where what's shown on other blocks, but,
Right, so here is Washington,
right?
and here's Jefferson.
But it's showing this is Fig and Nectarine. We're talking about between Pine and Strawberry.
You are right. So, I think there's still a value because it's showing all of these different blocks, and so some of the blocks, alleys are created,
Right.
and some of the blocks, the alleys are not created, and they go all the way to the edge, to the property line.
Right, I just find that conflicting because I know there are some streets that don't have alleys that are consistent all the way through the entire town. So it's hard for me to take that as evidence.
The actual root of the title that's referenced specifically, expressly in the deeds is the other one that you received, and that's that one, and that's showing the block without making any reference to.
Well, that doesn't have any alleys on it.
Without making any reference to, there's Nectarine, there's Plum,
Yes,
there's Strawberry
should be
Street,
down here.
Pine Street, and we have Jefferson and Washington, so this is block here.
Right,
And it's not showing any creation of any alleys. So our point is that in order for an alley to be created, it has to be accepted by the town.
Right.
And in order to be accepted, it has to be platted. And we have lots of deeds that are referencing very conditional language as sort of a, maybe it can be open all the way. However, that's up to certain owners. And you can see that it's not platted as a firm creation of an interest that's vested.
okay. Well, in this plat, the original plat of the town, which doesn't even include the below Pine, Harbor Street area and all that, and Bay Avenue, doesn't indicate any alleys. And I know there are several alleys in town. I don't know when they were
It's very
established.
possible that they were created by some other instruments that are referenced in those deeds.
Right.
But our deeds and our chain of title references this one.
Okay. Then I had a couple of other questions too. The one thing I'm trying to understand is, what is actually the definition of an alley? Does an alley have to have two entrances, or does it not necessarily have to have two entrances? I know of one other alley in town that I recently found that does not have two entrances. In fact, it goes in and kind of comes out into somebody's driveway. But it's used by several of those residents as an alley, and I think that's off behind Tazewell and off of Nectarine, I believe. Now, whether that's an alley that's recognized by the town or not, I don't know. But I do know that it's a gravel-looking alley. So my concern is, I'm just trying to figure out what the definition of an alley is with this wording here in the 1925 deed that states that it would be, could possibly be an alley open from Pine to Strawberry with consent of owners. So if we have non-consenting owners, that would mean, I'm trying to figure out, that would mean, would it stop partway, or would it not exist at all? And so that's kind of where I'm going with that. So then again, is this an alley or is it an easement? That's kind of where I sit right now.
I understand, okay. Anything else at present time?
No, that's it, thanks.
Okay, Pete, you, comments?
My initial inquiry was, what is an alley also, but I think it's been answered today, and it seems to be the weight of the evidence leans towards going all the way through. I think it's interesting that it seems that with this particular alley and location, the people that have the alley want it, and the people that don't have an alley don't want it. Just some thoughts. I was wondering when the rule of perpetuity may have expired, and then at that point, would that create an adversity, and which basically means that there things like a prescriptive easement could come into play, which is just that if you use an alley or an easement, that's, I don't know if we can equate those two things, but you know, with over the objections of your other interested parties, but they don't contest it or stop you from doing it, then you get, it's like adverse possession, but it has to do with easements. They call it a prescriptive easement. I know you're going to hear, we're only here in an appellate capacity, meaning that we have to take everything that was seen at the time by Katie and whether or not she had you know, good reason to rule the way she did. I've heard a lot today, which has just really created more questions in my mind than answers. The last thing is, you know, another thought for me is that, you know, instead of all this litigation and all this cost, maybe the attorneys could agree, and maybe the attorney for the town could agree to some kind of an appointment of someone on the shore, a special master, or special counsel. We've all heard that too many times. But we've got, you know, title searchers around here, you know, that have been doing this stuff for 30, 40 years, and just maybe we could get a report or something in that vein to help us make a decision, which would entail, you know, coming back again. But it's better than maybe it's better than people having to spend money to go up to Eastville to the courthouse. And so I know.
Just as a point of information, that is one of the options we have available today. We can vote to table this pending consultation with council, or I'll keep forgetting that. We can vote to, one of the options we do have is we could vote to table this pending the consultation with town council and get back together at another time to discuss and finalize our decision. That is an option we have, okay, just so that everyone's aware of that. Okay, Jim, do you have comments?
I sort of looked at where this property is in question and sort of reflected back in history. This is part of the town that didn't exist originally. This was actually the cottage addition part of the town that was then filled in and made as part of the town. So, and I believe that action took place around the 1920 timeframe. So, obviously, some things happened at that time frame. Also, one of the things that was sort of key in my mind is this is a large historic district. And those guidelines of this historic district were not actually put in place until about 1987. So some of those elements of what made this a historic town, the guidelines of the properties that are in this historic district that, and I don't know this because I haven't looked at it, does it include the easements as well as the alleyways and streets? For that reason, I'd like to do a little more homework, to be honest, to know, do those historical documents have any weight in terms of what we should be deciding on this? That's all.
Okay.
Yeah.
All right. I think my first comment would be just to once again say that this area is an old area, and we've already established it has the oldest court records anywhere. The county zoning was not even something that was a consideration, let alone what is an alley, what isn't an alley, for many, many years while the town was being built. There are a lot of, I guess we would say, grandfathered instances in the town where things that would not pass muster with today's zoning ordinance were done many, many years ago. And there is no, do I think there ever will be, any attempt to go back and make those people move your house 3 feet this way or that way or anything of that nature, because those were based on what we've had since July of 1994, and even more recently there's been a more serious attempt for the town to have uniformity in its zoning regulations and to enforce those regulations in a more robust manner. The reason for that is quite simply, if you're going to have a zoning ordinance, if you're going to have good zoning, you need to clearly establish what that zoning is, and you need to also back that up with a consistent application of those. So none of that excuses or anything of that matter mistakes that were made in the past or even in recent times. But my personal opinion is that any decisions that we make need to be based on what we know to be true today and what we feel is in the best interest of the town. Now, keeping in mind, those do have to be in some type of agreement with legalities, titles, deeds, and things of that matter. But once again, I'm not a lawyer, so I try to stay away from those type of finite definitions of certain things. As far as the rule of perpetuities, what I know about it, which is little, and we do have attorneys, former attorneys on the board, and I would say completely away from that in regards to this case, because we're not qualified, nor are we tasked to make a decision whether that in itself applies to the matter before us today. So I'm just going to state that I don't really think we can use the perpetuities rule as a reason. As I said, the zoning has been in place since 1994, and what we are here to do today, and certainly we've heard a lot of evidence, testimony both ways that say, well, it was applied here, it wasn't applied here, this fence is right in the supposed alley, this one is not. And the only thing I can go to there is, I'm not here, nor are we here to defend or excuse those mistakes. They've been acknowledged by the zoning administrator, they've been acknowledged by the town, and any action that would be forthcoming because of those mistakes, one way or another, would be an entirely different legal matter that we don't touch on, nor do we, or would we be entitled to touch on it from this board. So those are legal matters that would be handled an entirely different way. I have to go back to the simple reason, and setting aside all the legalities and everybody's feelings, which are all important, but the only thing we are here for today, and I emphasize this again, is, in our opinion, the testimony that's been presented, the evidence that we've seen, and what we've heard, do we feel that our zoning administrator made a proper call based upon what she had to work with, the research she did, and the information that she was able to gather? If we feel that she did make a proper call, then that should be our motion and our resolution. We're not saying that this is a legal decision, that everything she's had is said is completely defensible in court, and it's in strict compliance with the letter and intent of the law. We're not here for that, nor are we qualified to do that. It would simply be our interpretation that she did the best job she could based on what was available to her, and I do think, in all fairness, she did do an extensive amount of title search and looking. It wasn't a quick decision, and she has previously apologized, Mr. Elam, as you were due, for taking a long time in reaching this decision with you. And I understand your frustration with that. Frankly, I would be too. But I think she tried to give you the best reason behind that she could, and that's where that will have to stay. So I think, in my opinion, I feel like it's a very vague area what, and as Peter said, what is an alley, what's an easement? Those are things that might very well need to be dealt with in more detail going forward. Maybe the town needs a definition of exactly how each alley in town was established. I don't know that we could ever do that. Frankly, I'm not exactly sure what document, instrument, or what says, okay, this is the paper that says this alley between these two streets was created in 1940 or 1920, and it was valid then, it's valid now. Are there things that say, okay, before we could ever talk about whether it's a legal alley, every property owner that borders that alley has to give their consent? I don't know that that's a requirement. I also don't know where one would go to find examples that say this alley was legally established, this alley wasn't. It's a very complex issue, and again, to get too far into it, we'd be here till tomorrow this time. I will just simply say this. In my opinion, I think the zoning administrator made a proper call based on what she had and what was available and the research she did, trying to be consistent with the town's direction in zoning and trying to apply the present zoning laws to the best of their ability. Now, I'm not the decider. It's just one opinion. And so we want to talk about this more. And the options we have are, like I said, to accept that, or make a motion to accept that, to make a motion to say it was an incorrect decision, or to make a motion to table it depending on further consultation with town council and others, and reconvene at another time. So I think that's what's before us. And but please, I don't want anybody to leave here feeling like they didn't get a chance to discuss it, hash it out, or say exactly how they feel about it, because if we do that, we're not doing our job. I'm speaking to the board now. So before I call for a motion in one way or another, I'd like to go back, starting with Ms. Wygand, to sort of sum up and tell us what you think should happen going forward.
I'm kind of along the lines of feeling how Jim feels. I feel like I'm at the point where I would like to table this because I'm not convinced that this was a town-recognized alley, but yet I'm not convinced that an alley has to be all the way through from one street to the other, especially according to this deed, where it says by consent of owner. That may mean by consent of each owner. If each owner along that line wants to open it as an alley, great, or is that more of an easement? So I'm kind of feeling along the lines of tabling this right now to kind of research that a little bit more.
Okay, thank you. Pete?
Well, I feel the same way. It may be for some different reasons, but enough. Council has given me enough questions to ask. And, convince me in certain ways that that Mr. Elam, has a good argument. But certainly, however we get about it, more information I think will certainly benefit me, and I think it'll benefit the board as well.
Okay. Jim?
I'm in favor of tabling this for a while.
Okay.
Not a long while, but at least get
No.
more info. Yeah.
Yes. Okay, you've heard everybody's comments, and I'll say this. I'm not directly opposed to tabling it, but I can only give you my honest opinion. If we do get further counsel, I think we're going to get more different opinion and different take on it. And I think we may very well find ourselves back here in a month, 2 months, only to reach another conclusion that would require Mr. Elam to take the process further. That's just my opinion. I'm not saying that's what's going to happen. I have no way of knowing that. It's just my opinion. I would prefer myself to go ahead and tell you that I think the zoning administrator made a proper call based on what I've already talked about. And at that time, maybe offer the Elams a chance to say, okay, this is how we feel. Would you consider, just to get your final decision that's long overdue, would you consider moving your fence back 2 feet? Because, okay, well, I understand that. Yes, I'm just theorizing, and I'm not trying to put words in your mouth, and don't misunderstand my comments, please. Because I feel like in the interest of moving the thing forward and reaching a final call, it's probably going to end up in court anyway, just how I feel. Maybe, maybe not, okay? But I think the opinion, no, I'm not going to say that. Would someone on the board like to make a motion one way or another? Would anyone like to make a motion, any board members? I can't, as a chair, I should.
Well, I make a motion to table this till at least next month so we can get a little more information.
I will say, excuse me, I will say in May, we already have some business to take care of. We may not be able to get it back on the agenda in May. It may have to go, Katie, do we currently have anything in June?
I don't have any applications filed for a hearing in June at this point. Again, this will be contingent upon the calendar of our town council and working with the town manager to seek some of the information you've now requested.
Okay, so I just, we may not, we would try for next month, which would be, I think, May the 9th, but it might move into June. I can't, well, we can't say that right now, but, okay, so we have a motion to table it pending further discussion with council, and we have a second. All right, all in favor of tabling the motion as stated by Ms. Weigand, please say aye.
Aye.
Aye. Any opposed? All right. The motion will be tabled, and the town will take it up further, and notification will be sent out. Thank you all very much. We need to discuss, I'm sorry, election of officers and continue our annual meeting. Wish I'd never put that in my mouth. All right, so I think what we need to do first of all is accept nominations and vote chairman, vice chairman, and secretary. I will say this. Well, let's just go ahead. Do we have any nominations for chairman for the coming year? Nobody?
I nominate Bill Murphy
Okay.
as chairman.
Anyone else?
I'll second that.
Okay. Well, let's just vote. All in favor of me doing this for another year, say aye.
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 Aye, and I'm sorry.
And I, of course, abstain. Okay, that's fine. I don't have any problem with that for a year. Now,
Are you sure? Are you good with that?
yes, I am.
Okay.
Yeah, I will say that I would really like for this to be the last year as chairman. I like being on the board, but I think really it's the job that should rotate occasionally because people shouldn't sit in place forever, you know? I think this will be like my 5th year.
As long as you're okay with it.
Yeah, I'm fine for another year. That's
Okay.
good. So, all right.
Should have asked that before.
Oh, no, it's okay. Now, vice chair, I will share a little something with you. I've spoken with Pete about it, who's done a great job as vice chair. He sat in for a very difficult couple of meetings when I was in California. And he's expressed a desire to not be vice chairman for next year. Now, we may have to tie him up and threaten him before he leaves, but having known that, I was thinking very much about asking Dolores Blackburn a few consider, because Dolores has extensive experience as an attorney and as a town manager. She's done just about everything like that, but she's not here today, so we could go ahead and vote her in without her being here, but I guess we probably shouldn't do that.
Well, could make it conditional upon her.
Well, we could do that, or if anyone has any other nominations for anyone they'd like.
Based on that history, I would recommend that too then, if, I didn't realize that, so I think that's a great idea.
Dolores?
Yeah, I do.
All right.
As long as she's willing to step up, you know.
Okay. And if for some reason she says, I will not accept, nor will I run, we'll
Then I
just,
nominate Pete Bauman.
you would like to nominate Pete?
Yes.
Okay.
That's not gonna happen. There's a thing called an impossibility.
So hang on, procedurally, do I actually have a motion to nominate Dolores from you, Jim?
Yes.
Yes.
Then I would need a second to that.
Second.
Okay.
All right.
And
All
then
in
now-
favor?
Well, before you vote, because now here we have a second nomination from Laura of Pete. Do I have a second of that one?
Reluctantly, no.
Hearing that comes off. Okay, so now you're still left with one nomination of Dolores. Is that conditional upon Dolores accepting it?
I think it would have
Think
to
so,
be, yes.
yeah.
Okay, now take your votes. Sorry.
Okay. All right, all in favor of conditionally electing Dolores Blackburn as vice chair, please signify by aye.
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 Any opposed? Okay. Now, I need to contact her, Katie, or do we do that, or the town do that, or should I do
I
that?
will definitely have a conversation with her, but it wouldn't hurt for you to talk to her.
I will.
Just to explain at least whatever conversations you've had with Pete and all of that.
I will, I'll do that. Okay. Now, as far as secretary goes, I would assume that Tracy and,
Actually, it's going to change at
Okay.
this point. As I mentioned, we do have a staff person here today. So we have been doing some shifting of priorities within the department as a whole. We're trying to get some depth in the small rankings that we have. So we are going to be bringing Bob in to help assist me in staffing this board. Because his role is as a zoning compliance officer, so he works hand in hand in looking and administering the zoning ordinance with me. So it makes sense that he would help assist in staffing this board.
okay. All right, could we get a formal motion for that? Katie, you can make a motion, right?
No, I'm not a sitting member of this board at all. I'm your staff person.
Okay. All
So
right.
I nominate Robert
James.
James as secretary.
I would second that.
Second.
All right, all in favor of Robert James being our secretary for the coming year, please signify by saying aye.
Aye.
All right, that's a done deal, okay? So that should take care of it, pending Dolores, Ms. Blackburn accepting the job as vice chair, and Katie will reach out to her, and I will also, so we'll know, before the next meeting on that. Okay, now, one final thing. Our next scheduled meeting is May the 9th, and I think there's just one matter coming before the board. I won't be here for that. I will be en route to Parris Island, South Carolina. One of my grandsons is graduating Marine Corps boot camp, and I cannot miss that.
No, you
So, I won't be here for that particular meeting. So, Pete, do you have any problem vice chairing that meeting? Just to be sure we do have someone in place, and if Dolores accepts, you've done it before, so it might be a little much to accept her to take that, because I think this is going to be more of a routine.
That's correct. We do have one variance application that has been filed.
It's for a parking.
It's for relief from the parking regulations for an accessory dwelling unit.
It should certainly be not,
Sure.
won't be as much fun as this one, but yeah. Yeah, okay, so Pete will act as chairman for the May 9th meeting. And sort of along with that, Katie, as soon as you've had enough time to discuss it with people and set a date to reconvene, considering the matter here, I definitely want to, be present for that. Okay.
We had, well, off the record,
Well, we're still on the record, yeah. Okay, no, okay, I think that concludes all our official business for today, so unless there's some objection, I would like to go ahead and adjourn
Can I
formally.
make a motion, we adjourn then?
You certainly can. All right, all in favor of adjournment, say aye.
Aye.
Aye. Meeting is adjourned.